In other news, a sigh of relief for the local contractors. A decision in federal court could mean a green light for them to proceed in hiring H2-B workers for the island. Here's the decision by Chief District Court Judge Francis Tydinko-Gatewood on the H2-B visa denial case. For local contractors who have been suffering the consequences of near 100% denials, it's a victory. But Chief District Court Judge Francis Tydinko-Gatewood's decision does not put a clear rubber stamp of approval on H2-B visa applications. Not quite. Guam Contractors Association legal counsel attorney Jeff Joseph explains.
The government has to reopen all of the H2Bs that were denied from the named plaintiffs. And that those petitions need to be basically adjudicated.
In granting GCA's preliminary injunction and enjoining the USCIS from relying on temporary need as a basis for H2B denials, all visa applications previously submitted that were denied based on temporary need will need to be revisited.
So in other words, the government could possibly deny it on other grounds, but they cannot deny it on temporary need, and that's what all of the applications were denied on.
I guess if they were to remove that temporary need as a finding to deny a visa application, wouldn't that, and let's just say there's no fraud involved in any of these visa applications or overstays, and it's a perfect application besides the temporary need aspect, and because they can't use temporary need as a reason to reject these applications, what else would they be left with to use as a means of denying these applications?
Nothing. They should approve them.
Attorney Joseph says Judge Gatewood's order also applies prospectively so that any future applications submitted by local contractors to the USCIS cannot be denied based on temporary need. And with a preliminary injunction against the USCIS, Joseph says the case will now proceed on the merits. Another order issued by Judge Gatewood is on the employer's labor certifications, which will remain valid.
One of the ways that they could deny is simply say, well, the labor certification you received from Guam has since expired, and therefore we cannot approve your H2B application. And it would have been an easy out for the government. So anticipating that, we specifically requested that in order for the plaintiffs to be put back in the position they would have been in prior to 2015, that the labor certification issued from Guam would also have to be sort of nunc-pro-tunc validated through the period of the petition.
Although the judge denied GCA's motion to dismiss, she acknowledged, as did the U.S. magistrate judge, that the visa denials has caused irreparable harm. She said, quote, "The public interest weighs in the employer's favor. The absence of preliminary relief here poses various massive, concrete, and imminent risks of harm for the employers and the public more generally, from domino-like webs of bankruptcies and public health crises to environmental harms and stalled and substandard completion of projects critical to the nation's security and defense," end quote. For the plaintiffs, it's a huge sigh of relief.
They've been unbelievably patient and sort of waiting for this to happen. And, you know, we're not talking about small potatoes here. We're talking about millions and millions of dollars in mitigated damages. So tonight is the first night where they can kind of sleep soundly, knowing that they're not going to be looking at violating contracts and laying workers off and possibly going bankrupt.
And you can read the judge's decision online at pacificnewscenter.com.